2424311, Liberty et al. Versus Mack et al. I see counsel are present. I'm assuming ready to proceed. We are being streamed on the web both by audio and by video. I would ask that we start by having counsel introduce themselves together with the party they represent, starting with the appellant.
Gerald Schofield for the appellant Liberties, Your Honors.
Good morning, Your Honor. Stephen Cope Law Firm for the appellee.
Thank you. And Attorney Schofield, if you're ready to proceed, we'd be happy to hear your arguments.
Good morning, Your Honors. May it please the court. We're here today because a clear error was made when the Superior Court looked outside of the terms of a contract that should have afforded the appellants the ability to reacquire 17 LBJ Drive in Harrison, Maine, pursuant to a right of first refusal. While the procedural history of this matter is long and complex, the matter before this court on appeal is not, and can be narrowed down to a matter of contract law. The Superior Court has already held, and the appellee is not disputed in his brief, that the appellant's right of refusal was valid, enforceable, and was materially breached when the appellee granted an option agreement to Investment Properties LLC in February of 2016. The Superior Court's holding that the appellants did not prove damages was an error, because the court looked outside of the four corners of the option agreement to impute terms and conditions that did not exist, therefore leading to the conclusion that the appellants could not prove their damages. The option agreement was a contract, and the offer. A property owner who transfers property to a third-party buyer in violation of a right of first refusal creates an enforceable option in the right holder. Upon notice of a bona fide offer to purchase, the right of the first refusal ripens into an option to purchase the property at the price and otherwise on the terms stated in the offer. Section 6 of the option agreement, the offer, is clear. It states that the purchase price for the acquisition of the real estate shall be the short sale price obtained in negotiations with TD Bank plus closing costs. The Superior Court held that was $450,000. Section 9.1 of the option further states in pertinent part that the conveyance shall be made by warranty deed, free and clear of all encumbrances, and these terms are expressly acknowledged in the findings of the court. Section 12.9 of the option is consistent with Section 6 and 9.1, as it requires the seller, the appellee, to remove all exceptions at the seller's expense. Lastly, and importantly, Section 12.12 of the option agreement states that the agreement contains the entire and only agreement between the parties, and no oral statements or representations or prior written matter not contained with this agreement shall have any force and effect. The option is clear and unambiguous. The purchase price is clearly stated. Other terms could have been included by those parties, but were not, and it was error for the court to impute the same, which was the court's entire basis for finding that it couldn't calculate the appellant's damages. When such contract language is unambiguous, its interpretation must be determined by the four corners of the instrument without resort to extrinsic evidence. Contract language is only ambiguous when it is reasonably susceptible to multiple interpretations. The lower court did not find that the option agreement was ambiguous. It cited Section 6 and Section 9.1 specifically in its own findings of fact in the judgment, and those provisions are clear, not susceptible to multiple interpretation. Sections 12.9 and 12.12 are also clear in that the seller, not the buyer, must remove any exceptions at the seller's expense, and prior agreements simply don't matter. The court erred when it looked outside of the option agreement and held that it could not determine that the appellant's damages were $101,000.
I see the green light is on.
Thank you, Your Honor.
I'd like to turn to Section 12.9.
Sure.
You're correct. It does state that if the buyer objects to any exceptions, the seller shall use all due diligence to remove such exception at the seller's own expense within 30 days thereafter. But if notwithstanding seller's due diligence, exceptions cannot be removed. Let me stop there. What do you think cannot be removed means?
It would mean if they were not able to be removed. However, to the parties to this agreement were Investment Properties LLC, Mr. Lockwood, as well as Mr. Mack, and both were guarantors on the underlying loan obligations, which were attached to other properties, not just LBJ.
But what does it mean, cannot be removed?
It cannot be removed. It means that it's impossible to do so.
And why would it be impossible? For example, maybe the seller couldn't afford to do that?
That's one possibility, but I would posit to you it was possible because they could have negotiated a short sale. They could have done a number of things.
But there were other encumbrances on this property.
Yes, but they were also covered by other loans under a prior agreement, under a loan forbearance
How
agreement.
many junior mortgages were there? Actually, they were part of this same transaction, weren't they?
There were 3 or 4 other prior.
And what was the value of those encumbrances?
Originally, they were in the amount of $800,000, but they were a loan forbearance agreement and then a deferment, and they eventually were down to around $359,000.
So your argument depends upon either Mr. Mack's or Investment Properties or somebody, whoever the seller is, ability to pay off those encumbrances and remove the title impediments, right?
Which it should have done, because the option agreement states that the price is the TD Bank loan, and had they wanted those other loans to be paid, that would have been included in the purchase price.
But there's a safety valve in 12.9, and it says if the buyer, that the buyer may elect, if the seller can't remove those encumbrances, that the buyer may elect to purchase the real estate as is, basically, encumbered, or walk away from the deal.
The Liberties, had they been able to step into the shoes of Investment Properties LLC at the time of the option agreement, it's my position that they could have in fact compelled the payoff of those loans, because Mr. Lockwood himself, Investment Properties, was a party there too. And because those loans secured other properties that did have adequate security, any number of things could have been done, including
But
a short
this
sale.
was basically Lockwood's option, right? The option agreement was basically his option.
The option agreement was to
And he
Investment
never
Properties
exercised it.
LLC.
He never exercised it. Why didn't he ever exercise the option?
I can't speak to why he didn't.
Could
but
he afford to?
I don't know that,
Isn't
Your
that
Honor.
really the crux of this
It's
issue?
possible, but the problem is my client had a contract which was held to be valid by the lower court that says they should have been offered that. And had they been able to step into those shoes, it is our position that they could have forced in the shoes of investment that payoff by
But
securing
it
a
doesn't
short
say
sale
they can
otherwise.
force the payoff. It says the seller will use all due diligence. It doesn't, it's not an absolute.
No, and the seller didn't use any due diligence, and it also says within 30 days, but the buyer also had the option to extend that period of time in the buyer's sole discretion to effectuate that. But my client was deprived of that opportunity because his right of first refusal was materially breached as found by the lower court.
Is there evidence in the record to show that your clients could have paid this off, or that Mr. Lockwood could have paid this off?
I don't believe there's record evidence in the below.
Isn't that necessary? Isn't that your burden to put that evidence in?
Under my position, no, because had those junior loans been required to be paid off, they should have been within the contract. And unfortunately, it's our position that the lower court imputed that term within the contract, which doesn't otherwise exist related to the purchase price. And the parties
Imputed what
could have
term?
imputed that the Atlantic debt was also part of the purchase price for the payoff, when that's not what the option agreement
Well,
says.
somebody
in all
had
due
to either
respect.
pay it or else your clients had to pay it. I mean, if somebody else didn't pay it, right?
It says exactly who was supposed to do that, the seller, so the
It
seller
says
could have
use
paid
due
those.
diligence. And was there proof in this case that the seller reasonably could have paid that off?
I believe that there was, because there was equity in the property at 750 Warren Avenue in Portland, Maine, as well as the Lewiston properties that, had the seller used any due diligence at all, could have been used to sell to pay off these mortgages. The problem is the seller didn't do anything at all and simply stood by and didn't do it. even
Isn't
though it
this
was
an
a
issue of
requirement.
the sufficiency of the evidence? I mean, the judge below wasn't persuaded, essentially, that you had shown that it could have or should have been paid off by the seller or by, for that matter, investment properties.
Yes, Your Honor, but it would be my position that the actual payoff amount that my clients paid to purchase the property, $551, was demonstrated, that the amount of the TD loan was sufficiently demonstrated at trial and found in the judgment, which was $450,000, and therefore the amount that my client were damaged pursuant to being deprived of its right of first refusal was $101,000.
But that's ignoring 12.9 and who and whether the impediments, i.e. the Atlantic loans, could have been paid off by anyone.
And if those loans were supposed to have been, it's our position they should have been included within the option agreement, but they were not. And the parties to those loans could have easily included them. They chose not to do
Well,
so.
I didn't say it had to be paid by your client, but somebody had to pay them.
Correct, and it says that all encumbrances shall be paid by the seller at seller's expense. within 30 days or such additional time as buyer may allow in buyer's sole discretion. By
But
buyer-
your computation of damages assumes that certain things would have taken place back then. And I think the judge here seems to be uncomfortable to assume that this would have taken place, that may not have taken place, and what the standards were. And doing the math after the fact couldn't arrive at a meaningful calculus to get to the figure that you're posing here today.
That is what Justice McKeon found, Your Honor. However, it's our position that the math is actually relatively easy if we boil it down to what the contract says.
But there's assumptions in there that would have happened. You know, the payments would have been made, due diligence would have been exercised, and all the rest of it. But we really don't know what the past would have held because that's not the route it took.
Doesn't it turn, in other words, on the assumption that due diligence by the seller would in fact have resulted in payoff of the Atlantic debt?
Yes, and I think that's exactly it. And Justice McKeon stated that the appellants could not have compelled the payoff. And it's my position that standing in the shoes of investment properties, who were the person who were given the option agreement, the offer, they could in fact have enforced that because Mr. Lockwood himself could have enforced it because he was the person granted the offer. He was also a guarantor on those other loans along with Mr. Mack, and therefore could have short-saled other properties, could have done any number of things, but it could have and should have been done pursuant to the contract.
But
because it says it's
compelling the payments, I suppose they can call up and say, make this payment, and it happens. The other alternatives is incredibly expensive litigation, drags on for years, runs into the hundreds of thousands of dollars. We just don't know what would have happened back in the day.
And Mr. Lockwood had no obligation. He's the buyer. He's not the seller.
No, he was not, but he was also a guarantor on some of those other loans with Atlantic National Trust and with Atlantic Capital Finance Company.
There don't appear to be additional questions. Thank you.
Thank you, Your Honors. I appreciate your time.
And Attorney Cope, we're happy to hear your argument.
Thank you. May it please the court. The appellant's issue before the court, as identified in their brief, is whether the appellants have a cognizable claim for damages arising from a putative right of first refusal applied to the option agreement, as we've been talking about. We did controvert the issue of whether there was a right of first refusal, but we didn't elaborate on that in the brief because the issue that was presented by the appellant was limited to basically whether there was a provision in the contract that should have been given cognizance. That's paragraph 12.9, which in their brief they completely ignored. They're talking about it now, but they didn't address it. And the court, in the trial court, spent a considerable amount of time addressing the implication of 12.9. I will talk about it later, but before I do that, I just want to emphasize that on page 20 of my brief, I did address the issue of what the right of first refusal was. Yes, the court below found that a release signed only by the Liberties constituted a binding contract. That contract is not identified beyond the existence, as the court said, it was a contract. It's not clear from the findings who the parties were. At best, the party was Big Mack Development that took the immediate title from the Johnsons, who sold at the time that this release was given. The release is not signed by the Johnsons. It's not signed by Big Mack Development. It's not signed by anybody. It presumably refers to something else, an agreement that is not otherwise memorialized. There's no writing. There's no contract. There's nothing of record other than a reference which the court below said in the context of the first summary judgment effort was ambiguous. Later on, the court said it is clear that it created a binding contract, but it's not clear that the binding contract, whatever it may have been, was binding upon Alvin Mack. The record and the court decided that the record made it clear that he may have been obligated by notice, by the fact that there may have been discussion. The record is clear that it was recorded after the original closing to Big Mac, and he might have been on record of noticing what might have been a recorded release. But several title examinations by prominent law firms did not detect this. Now, there may be a question about that, but they did not, and people were entitled to rely upon that. So there's no evidence, and the court ruled that Alvin Mack did not assume any obligations. So what we have here, and what I've raised, is that while there may be some, even if he had notice, that doesn't, by contract law, make him liable. It could create a situation where he is liable to an equitable action for specific performance, as we saw in Van Dam v. Spickler, but that doesn't translate to damages. That only makes him potentially liable to have given notice. Now, what we're talking about...
So, counsel, just to be clear, are you challenging the court's, the trial court's factual findings on that?
No, I'm not challenging the
its
factual
legal
findings.
conclusion?
What I'm saying is, as a matter of law, I think, and let me just elaborate briefly on that. As a matter of law, what I'm really saying is that whatever may have been an agreement to create a right of first refusal was not the 1985 right of first refusal that was a matter of record, because that was binary. You either, just like the option, you either accept it and exercise your rights to purchase, or you don't. What I'm saying is, arguably, at best, as a matter of law, what existed at the time this option agreement was signed was possibly an equitable liability for specific performance, but not a claim for damages.
When you said at the time this option agreement was signed, are you talking about the 2016, 2009? What do you...
What I'm saying is that the result of the 2009 transaction
Okay.
essentially gave the Liberties an opportunity to either buy or not buy. They had a choice. They made a choice at that time to release it. The fact that the release is conditional is, in my view, irrelevant, because they didn't have the legal power, as contractually or otherwise, to create conditions. They entered into a contract with the Johnsons in 1985.
So you're saying the 1985 option agreement was extinguished?
Was extinguished as a result of the release. The extra language in the release that said it's only applicable to this contract is just it's unenforceable surplusage. It doesn't. It was terminated. Whatever may have existed by the court's determination that a binding contract existed as a result of a unilateral action by the Liberties in releasing their interest might, at best, create an equitable a liability for specific performance, but it doesn't create a basis for damages.
Would you address the damages issue in
Yes.
in section 12.9 specifically?
Yes. I raised that the option agreement contained, first of all, the option agreement was never exercised. So it was out there. It was had a 2-year term. The issue, there is evidence in the record that Mr. Lockwood said the reason he didn't exercise the option was because he didn't have the money to pay off the Atlantic loans that had been put on. The damage question under paragraph 12.9 is fairly straightforward. It is not a default provision. It is a condition. The condition needs to be satisfied, and the parties agreed that if it wasn't satisfied, they would have an opportunity to either walk away, the buyer could walk away, or the buyer could accept. That's not an uncommon provision when it comes to various title encumbrances. I see that all the time in all my years of practice in contracts. If there's a title problem, whatever that title problem may be, encumbrance is a broad term, if it can't be resolved, it may be grounds for termination.
But
of the
Attorney
contract.
Schofield is asserting that under that provision, 12.9, that your clients, had they used any due diligence, would indeed have been able to remove those encumbrances, and under this option would have had the obligation to do so, leaving them to take title for the balance of the short sale amount of the TD Bank loan.
Yes, they would have had an obligation to try. There's no evidence that they couldn't or that they could, other than the vast evidence that was introduced in the testimony of the Atlantic representative and my client about a series of forbearance agreements, all of which are in the appendix. The reason that this was a problem is because there were financial issues. My client had financial issues. Lockwood had financial issues. The record contains the forbearance agreement. I could give you the page number in a minute. It was the following year where there was a document which referred to the outstanding balance of about $358,000 owed to investment properties that had been guaranteed or directly made Alvin Mack liable. There were financial problems throughout. The trial record is clear that that's the case.
I understand that, but it sounds like what you're saying is there was at least evidence to support the judge's order in this case, but the judge didn't really say that they couldn't do it. He said that that there was no evidence of the damages, which is a little different, isn't it?
Well, the burden of proof on this case is clearly with the plaintiff in the trial. It was their obligation to say that there had been no due diligence, there had been due diligence, that could have, that couldn't have, how that was done. That's not, the court saying that there was no evidence of damages, which broadly says that the plaintiff didn't prove their case, didn't prove what they would have had to pay if they had exercised the option, if they had stood in the shoes. And there was, as I say, ample evidence in the record to show that due diligence. The only lender that was lending money was investment properties. They're the ones who put the mortgages on this property at the same time as the option agreement was done.
Just so I'm clear, are you suggesting that the forbearance agreements that are in the record is the evidence of the due diligence?
There is other
or are you pointing
testimony.
to something else?
I don't know if there was testimony that said at the time, I don't think there's any evidence of any witnesses testifying. I could be wrong about that in 2016 that was the case. But there were, I think the Atlantic representative said that he was concerned about the status of the loans that were outstanding that were partially secured, which is the reason why.
You're suggesting that the evidence is replete with, that the record
is replete with evidence
of a lack of financial ability or that they were in financial trouble, so to assume that they could have paid it off would not be necessarily a logical.
That is my view, both direct evidence and evidence from which the court would reasonably be entitled to draw, inference. And that was clear by the testimony, as I say, of the representative from Atlantic. He said he wanted the extra mortgages because they had concerns about their collateral position and the ability to pay. And there were existing defaults evidenced by the forbearance agreement, which was entered into the following year, and a series of them, until 2 years later from this option agreement, where the property, the variety property, including the property that was referenced by Mr. Schofield, were transferred to Atlantic by deed in lieu of foreclosure. So these were not sold. They may have been attempted to be sold, but they were not sold. They were ultimately handed back in satisfaction of Mr. Mack's liability on the mortgages. The mortgages were not satisfied, but his liability was. But there's ample evidence to show that there was issues with regarding his ability to perform. And to be fair, the whole issue of the enforcement of this contract has never been tested. If the parties to this agreement, who all uniformly testified in court that it was the intention that when they entered into this agreement as part of, and the whole agenda is in the appendix, the whole agenda of all the various loans transactions, collateral loans, new loans with new collateral, all that was done at one time, there is really no question that the intention of the parties uniformly testified to was that these mortgages had to be satisfied in order for the option to be agreed. Arguably, if the agreement didn't say that, if it were tested between these parties, clearly there was a mutual mistake. That's not what they intended, and they said so on the record, everyone, without question, without challenge. So there's really no doubt that this was contemplated, perhaps by the drafter, that if these mortgages were not satisfied, then you could either try to find a way. I don't understand exactly what the short sale was, because the appraisal in the record shows the property was substantially worth substantially more than the $450,000 to TD Bank. That real estate appraisal was commissioned by Atlantic because they were taking all these mortgages on the property. So the short sale would have been as to their own mortgages, which they had just had put on the property.
I take it from your comments that there was never any litigation between any of these parties about issues of enforcement or who had to do what until this case right here? Was there anything, any
There's
efforts to get enforcement or?
No, no other cases. Lockwood sought to, I identified this in my brief, in the procedural aspect. Lockwood sought to join, and his efforts didn't pan out. He didn't follow the rule, and the court denied it without prejudice. He never pursued it.
So there's never been a proceeding with everybody present under the same umbrella?
No, the Big Mac was never served. They were the ones who ostensibly had the liability for the right of first refusal. AMJK, which is the party to the secret right of first refusal, was never named as a party. The Johnsons attempted to be named as parties. They didn't. They weren't joined. So the only one, and Atlantic, which settled. And that's an important piece, because I think that the equitable obligation with respect to right of first refusal was satisfied. I made that clear to the court 3 years before trial when we had a status conference, that settlement, where it was sold for basically a value of $551,000, which was nearly $150,000 less than what they would have had to pay to Atlantic, basically solved the equitable issue of a right of first refusal. If they had a chance, if they didn't forfeit essentially or terminate their chance in 2009, then they had an equitable opportunity at some point. They exercised it. They sued Atlantic. Atlantic settled. They bought the property. I think that solved it. I don't think there's any remaining equitable exposure for a right of first refusal. And that deal was even substantially less than what they would have had to do had they purchased under this option. So I don't think there's any legal liability for damages. I think that as a matter of law, paragraph 12.9 is a condition. The condition allowed the parties to go in a particular approach, assuming that, in fact, the option had been exercised, but hypothetically, assuming it had been exercised, that would be the best. There would be defenses to the case, as I mentioned in my brief, and none of this was established or proved by the plaintiff's appellant when they were in trial. The court was right. I think the end result is right. I think they settled for an amount that saved them money. They didn't prove their damages. Not that they didn't know that this was an issue, had been raised and on the table for a long time. Thank you, Your Honor.
And Attorney Schofield, you reserve some time for rebuttal.
Counsel, could you just respond to those last couple of points that the co-counsel made, Mr. Cope made, that one, the right of first refusal was effectively exercised. I mean, the Liberties did end up purchasing the property, and the amount they paid to purchase the property is probably far less than the value of the property itself. So where are the damages here, and where's the liability?
Yes, Your Honor. The damages stem from the fact that the court found that the Liberties' total cost to acquire the property was $551,000. That's judgment paragraph 50. The Liberties had to pay to Atlantic to acquire the property $155,000. That's the judgment at 50 as well. They also had to pay off the TD Bank loan for the sum of $395,755. That comprises the total $551,000. It is our position as the appellants that had the option agreement been in place at the time and my client given their contractual right of first refusal, which, by the way, was found to be valid by the court. They said the existence of the agreement of the right of first refusal and limited release was in fact effective, contrary to what we just heard. That's judgment page 10. They found that there was a material breach thereof. That's in judgment page 10 or 11. Had we been able to step in at the time of the option agreement, there was testimony on the record that the total cost to pay off TD Bank would have been $450,000. That's the judgment at 40. So when my client had to pay $551,000 years later, after he found out that his option was materially breached, he had to pay $101,000 more than he should have had to pay in order to be able to purchase this property.
Again, dependent on the fact that the seller could have cleared the Atlantic debt.
Correct, and because of the fact that both Mr. Lockwood as Investment Properties LLC and Mr. Mack were parties to the option agreement, had they wanted to include anything other than the written agreement itself, Section 12.12 of that agreement says no other agreements are valid and binding upon either of these parties. And it's very clear what the purchase price, if Mr. Investment Properties LLC were to exercise that option, were.
It's clear that it was 400 or approximately 450, i.e. the short sale price to TD Bank.
Correct.
Subject to, given that there were other encumbrances, the seller clearing those encumbrances.
That's not, in fact, in my opinion, Your Honor, what it
Or the
says.
buyer assuming them.
Right, it says that the seller shall remove all exceptions to title and shall do so within 30 days or such other time as the buyer may allow in the buyer's sole discretion, meaning that they could have forced those to be paid off because they were the seller's obligation. And if they were supposed to become the buyer's obligation, they should have put that in the option agreement so that the optionee would have known exactly what they would have had to pay at the time.
Well, it says shall use due diligence. It doesn't say, in other words, shall try. It doesn't say shall.
And they didn't make any efforts because there's no record efforts that they attempted to make any effort to pay off those loans. And they didn't do so because there were other loans that, you're correct, there was a whole series of other
But
loans.
isn't it your burden to show not just that they did use or didn't use due diligence, but also had they used due diligence that the seller would in fact have been able to clear that debt?
And I think through the record evidence of what Attorney Cope was talking about, there were various loan modifications agreement with Atlantic, forbearance agreements. The forbearance agreement and the loan modification agreement required payoff of certain loans in a certain order. And had that been followed, there were other properties such as Warren Ave, which was secured, as well as LBJ property, that's the subject, that could have been sold and that it could have been paid off. So had they done so and paid them off in that order, it's our position that those could have been cleared, and they could have been cleared with reasonable diligence. My client just was never given the opportunity because their right was
Understood.
breached and they couldn't step in and do so.
Thank you, counsel. Thank you. Well, as is our usual practice, we will take the matter under advisement, issue a written decision in due course. With that, we'll be in recess on this matter.
All rise.
morning. You can be seated. The matter before the court is BCD 24316, Ann Cannon et al. Versus the Town of Mount Desert et al. We are being streamed live on the web, both by video and by audio. I would ask, before we begin, that counsel identify themselves by saying their names for the record, together with the party you represent. Let's start with the appellant.
Grady Burns, Bernstein Schur, for the named appellants Ann Cannon, Mark Cannon, Melissa Cannon Guzzi, Stuart Janney, Lamont Harris, Joseph Ryerson, and Lynn Wheat.
Okay? You could have done the et al., but that's okay. I'm sure your clients appreciate it. For appellees.
Yes, Your Honor. Andrew Hamilton for the Town of Mount Desert.
Good morning, Daniel Pelleggi for Mount Desert 365.
Thank you. And Attorney Burns, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Madam Chief Justice, and may it please the court. The town of Mount Desert, like many communities in our state, has struggled with the issue of affordable housing for decades. To that end, the town adopted standards now over 20 years ago that introduced more flexible forms of housing. Those are workforce and cluster housing subdivisions contained in section 5.16 of the town's subdivision ordinance. Written into the purpose statement of that section, establishing those developments, is a list of competing goals, illustrating a legislative desire to balance the development of year-round housing and the protection of open space and the existing character of the community. These competing goals are underscored by a letter that was submitted to the planning board below by one of the original drafters of this ordinance. That's contained at record 368 to 372. That letter notes these competing issues were top of mind for the drafters 20 years ago. Striking that appropriate balance is at the heart of this case. The town of Mount Desert committed several legal errors when it approved this project. While the through line between those errors is an admirable goal on the town's part to increase local housing stock, the town's eagerness here resulted in an approval that circumvents key standards contained within the town's ordinances. The first issue to which I would draw the court's attention is that the planning board erred in concluding that this development would not create 3 or more lots, as that term is defined in the town's ordinances. Under the town's ordinances, much like the statewide subdivision law or the Black's Law definition of a lot exists where there is a parcel of land described in a legal document that is all contiguous land within the same ownership. In other words, there must be a distinct legal ownership interest that is traceable on the face of the earth. That is the case here. The planning board was required to address this legal question because several of the town's substantive standards turn on whether a certain number of lots are created in the development. Nevertheless, while the planning board's decision states its legal conclusion that no new lots were created, it does not describe how it reached that decision. However, the planning board, like the court here, would have needed to have begun at the applicant's own description of the legal interests intended to be conveyed within the subdivision. That evidence is necessarily found in the declaration of condominium included in the application. The plain language of section 3.2 of the Declaration of Condominium provided for the town's review defines the unit boundaries of these units as, quote, everything within the bounds of the depicted sites. The declaration does not say everything except the land. Nevertheless, the appellees now need to argue that everything actually includes less than everything, acknowledging that if everything includes the underlying land on the property, these units are unmistakably legal lots. To that end, section 10.1 of the declaration goes on.
I see the green light is on, and you have appropriately taken us to the Declaration of Condominium. We're looking through it. And as I go through it, looking at the language, it seems as though the drafters have been very clear to create what they call units, which would be the individual houses that are described there, and you've referred to them previously. Never does it call them lots. On the contrary, the lots is only reference to the entire property itself. No new lot lines are proposed, and the 6 homeowners would share ownership of the land. It appears on the face of it to be a very clear condominium project. You've got one piece of real estate with units within it that the parties would own. You have referenced the fact that they have, in fact, called them units and not lots, and there's no conveyance in here that would comply with conveyances of real estate. So my first pass through this, it occurred to me that this is a condominium project with units in it, but you read it differently.
Yes, Your Honor. So the term unit here is used throughout the document, but the actual interests conveyed here are what the court needs to look at in determining the scope of the interests intended to be conveyed. This was the evidence that was before the planning board in determining whether or not legal lots were conveyed. The declaration of condominium itself distinguishes between the unit and the improvements built thereupon the unit. Definitionally, then, the unit must be more inclusive than simply the building or some amount of the structures that are contained on top of the property.
So you're saying there's an implicit conveyance of real estate within this document?
There is, I would argue, an explicit description of unit boundaries that
Right.
depict the underlying land on the site.
I'm not sure why it matters that the declarations may or may not refer to the land. In other words, if all of the owners, meaning everyone, owns everything, which is what they say, essentially, then by definition, what is owned, possibly including the land, is undivided, isn't it?
The unit owners own their individual units in fee. The question, therefore, is what...
That's true in every condominium, right?
Yes.
Okay. So why is that different?
Because the description here states that the unit contains more than simply the interior of a building or what you would consider to be the paradigmatic example of a condominium. A condominium can contain the underlying land. And it's the description here that sets out the unit boundaries that would dictate whether that underlying land would be conveyed.
Do you know, counsel, in other, it's not a matter of record, but just out of curiosity, in other condominium declarations, is there a separate definition for unit boundary as opposed to unit?
I would point the court to the Garrity case that was cited in the briefing, where there was, in fact, a very specific description of the unit boundaries that were contained in that declaration. That unit boundary at issue included language relating to the unit being bounded by everything above the floor, inside the walls, below the ceiling. Those are prototypical examples of condominium developments where you have, for example, several attached structures within a single large building that clearly lay out where the common areas end and where the unit begins. That language could have been used here. It wasn't. The appellees in their briefs, when they assert that no land was conveyed, the language that they use in their briefing is, in fact, much more specific than the language used in the declaration itself. If the declaration wanted to convey something of a limited nature, it certainly could have done so.
To what deference do we owe the planning board in interpreting their own ordinance?
So the interpretation of the ordinance itself is reviewed de novo, Your Honor. The issue here is that the planning board gave no treatment in the decision whatsoever to the language within the declaration of condominium. They concluded that no new lots were created, but they did not deal with what the language itself indicates. That question of the language of the condominium is also a question reviewed de novo by this court. Those legal questions are purely interpretive. And if lots are created, if there are interests of sufficient dignity that result in separate fee owners whose property boundaries are visible and traceable on the face of the earth, that would be sufficient in the town's own ordinances to create lots that would then trigger the substantive provisions of the town's ordinances.
Can I take you to some of your secondary arguments here? We talk about density for a moment. As you know, the planning board made some calculations following what they believe to be the appropriate formula and applying the bonus and all the rest of that. As I understand it, your argument is that the planning board should have rounded down to the nearest number, and I'm not clear on what authority there is for that. It would seem to me it makes sense to use the actual number.
So the rounding up or rounding down is a bit of a red herring, Your Honor. And I'm happy to walk the court through the calculation here, and forgive me for using a lot of math.
Do you just want to stand on your brief then?
No, Your Honor.
I understand the math. I think the question, and I think we all actually did get the math. The question is, why should the planning board be required to go down to 3 when the actual calculation of this lot, which is just slightly under 40,000 square feet, results in 3.9, which is not the final number. If you were ending there, obviously you can't have 0.9 units. But that's not the end of the calculation. What is there in the ordinance that compels, at that stage of the calculation, the planning board to round down to 3?
The answer to that question, Your Honor, would be found in section 5.16.2.2A of the ordinance. That section first sets out that the density of the subdivision shall not exceed the density requirements of the underlying zone. It then sets out a way to calculate the appropriate density for a cluster or a workforce housing subdivision. It begins with the appropriate minimum lot size for that zone, which here is 10,000 square feet. And it then directs you to apply that minimum lot size to the either developable portion of the parcel or the entire parcel. And that number would be the base density of the lot.
Which is 39,000 and some odd square feet.
So here, it would be 1 lot per 10,000 square feet would be the underlying ratio. So in any normal land use calculation, the number you would arrive at if there were no density bonus here would be 3 units, because there is 1
As I said, I understand that.
Yes.
What is it, since that is not the end of the calculation, what is it in this ordinance that requires at that stage of the calculation, before it is completed, the planning board to round down?
The density bonus is applied to the density itself. That density is 1 lot per 10,000 square feet. So it would either be 1.7 units per 10,000 square feet or 1 unit per 7,500 square feet. Either way, that result would give you roughly 5.2 allowable units. The developer and the town adopted a calculation that essentially artificially increases the lot size itself and does not actually relate to the underlying allowed density, which is a ratio of 1 unit per 10,000 square feet. You reduce the allowable size to 7,500 or increase the allowed number of units per 10,000 square feet by that 75%, you arrive at 5 and not 6, which is a logical result. I see my time is up.
Thank you. And I understand, let's see, Attorney Hamilton, you're arguing first?
Yes, Your Honor. Good morning, all. May it please the court, Andrew Hamilton of Eaton Peabody for the town of Mount Desert. This case presents a challenge to the well-founded socioeconomic objective of the town for a well-planned increase in the density in a given zoning district for affordable year-round workforce housing. I would note that workforce subdivisions under the subdivision ordinance are categorically distinct from cluster subdivisions. There's been some confusion in this proceeding about that, but I think the plain text of the ordinance straightens that out. Bottom line is the town faces a severe shortage of affordable workforce housing. That affects employers and employees on Mount Desert Island alike. Communities that were thriving year-round communities have become seasonal residences, and the life of the community has been affected substantially. This community has planned for its future. It has said, as Attorney Burns cited, for decades, the town has had on the books workforce housing provisions, particularly as to the subdivision ordinance. It provides specifically for workforce subdivisions that get a density bonus and are subject to a different set of calculations than the distinct cluster or open space form of subdivision. I would like to address the suggestion that the condominium is unclear. I have for years practiced with a gentleman, John Cunningham, who understands condominiums. I conferred with him as counsel for the planning board at an early stage, and he told me, look to the subdivision plat. You look to the declaration, as Justice Meade's comment suggests, but you also look to the subdivision plat. The subdivision plat is very clear. You've essentially got 6 individual units and then common area. And I don't agree with Attorney Burns when he says there's an interest by everyone in everything. In the common area, that's true, but not in the individual units. And we know that the condominium statute can create distinct interests in real estate. That's why we have the Maine Condominium Act. So I think in toto, this is a case where there's confusion about what the condominium is or isn't, and I think that leads to confusion about how you count lots. The definition of lot in the land use ordinance, which is referenced in the subdivision ordinance, is very clear. And I need not say more than the 40-page decision that more than adequately discusses each of the considerations of lots, roadways versus driveways. Those are all very clear. But what's really happening here, I think, is that some seasonal residents that have bought and converted year-round homes are now worried about the density of year-round housing. That's a community choice. That's not an individual neighborhood choice. That's a community choice. And there are issues with the legislative body.
Counsel, I see the green light is on.
Yes, I defer.
And can you go to the issue of workforce subdivision versus cluster subdivision versus workforce housing when it comes to, and I think the issue that impacts is the open space requirement under 5.16.2.3A. And let me just be clear what I'm getting at.
Sure.
I understand that what was said below is that there's a difference between the workforce subdivision versus a workforce housing, as that term is used in the open space requirement. But workforce housing seems to be the phrase used throughout. When it comes to the density bonus, that's the phrase. Is there a separate provision? I didn't find it, that's why I'm asking. Is there a separate provision in the subdivision ordinance that would govern the requirements of workforce subdivision as opposed to 5.16?
Your Honor, I think the drafters of the ordinance and truly town meeting, which adopted these ordinance provisions, used the concept of workforce subdivision and workforce housing somewhat interchangeably.
It seemed that way to me.
Yes.
So then that leads me back to 5.16.2.3A, the open space requirements.
Yep.
And how is that appropriately applied in this case?
So in the subdivision ordinance standards, which are discussed at the appendix at page A056, we get into these questions of how are the buffer standards applied and how are the open space requirements
Mr. Pelleggi,
applied.
he's going over time. I want him to answer the question if that's okay.
So I'll be brief because I really think that what happened here is that we had arguments from each of the applicant and from the neighbor opponents. And what the planning board had to do is keep coming back to the plain text of the ordinance. And I think the answer is there in the findings. There is detailed discussion of the ordinance standards. And what the planning board encouraged themselves to do, and they were encouraged by council from time to time, is keep coming back to the plain language, the text of the ordinance. I'm sorry if that doesn't fully answer your question, but I want to be deferential to my colleague.
Thank you.
Thank you.
Maybe you want to answer
Good
that
morning.
question.
I'd be happy to start with that. Thank you, and thanks for the time. The subdivision ordinance and the land use ordinance in Southwest, in Mount Desert have to be read in conjunction with one another. Section 3.5 of the land use ordinance, dimensional standards, Your Honor, talk about exactly the distinction that you are making. And in section 3.5, the town makes a distinction between cluster subdivisions with or without sewer and a workforce subdivision. It applies different dimensional standards to each. The workforce subdivision dimensional standards in the VR1 zoning district are the state minimum, while cluster subdivisions with and without sewer have different delineated square feet. So the town contemplated, within the scope of workforce housing as is discussed in the subdivision ordinance, the concept of workforce subdivisions.
But then when you get to the subdivision ordinance, it says under 5.16 that it talks about it being cluster and workforce subdivisions being permitted in all zones. And then it talks about workforce housing. And so I guess I'm not, it's hard, it seems like this ordinance, as Mr. Hamilton actually said, seems to use workforce subdivision and workforce housing interchangeably.
And the thing, just following up, the thing that hangs me up is coming down to subsection 3, open space requirements. As you know, the title says, the cluster subdivision must include open space and meets the following requirements. That's the heading on that section. Then you go down to subsection A and make the reference. And then the last sentence, open space requirement for workforce housing. When calculating open space for qualified workforce housing, the density bonus units shall be excluded. But the density bonus units relate to workforce subdivisions. Isn't that right?
Well, the density bonus formula applies to workforce housing and subdivisions. It has to, because the subdivision is by definition, I see Your Honor shaking your head, but that's the only way to logically read the ordinances together.
I'm not shaking my head.
Oh, okay.
I was just noting that it actually talks, the density bonus refers to workforce housing, not subdivision.
It does, and the planning board was presented with a record that demonstrates that workforce housing covenants are included in both the subdivision requirements and in the pricing and resale formulas for individual unit owners.
So is this development subject to the workforce housing open space requirements?
Well, so for workforce housing, the open space requirement for 516.23A ties the workforce housing subdivision to the total lot and density, removing density bonus items. So that gets us units. So that gets us to our 3 units.
So are you just suggesting it meets that requirement?
It does meet the requirement.
Okay,
The pure math, the math that the planning board went through, where we take out the 3 bonus units, and we have, as the court discussed with Mr. Burns, we've got density, we've got 3 allowable units without any density bonus on an almost 40,000 square foot lot. So if we remove the density bonus, we have 3 units that are allowed without a bonus on the parcel. Those 3 units are allowed without any reduction in lot size. So therefore, reading the literal plain language of 516.23A is that there is no open space requirement.
Doesn't 516.2C require the 75% to be applied to the 3? In other words, 3 times 75%? Or 3 plus 75% of 3?
It's times 1.75, yeah. So it's 3 units that are allowed without any bonus.
But 6 units is 100% of 3, right?
We are allowed 3.9 plus units as the base density. Multiplying 3.9 times 1.75.
But 3.9 is not the density.
It is the density. Respectfully, that is exactly what the density is. We just can't build 9/10 of a unit. The density is the fractional unit. You'll see in the ordinance, it tells us to use all of the land. That's a specific direction to the planning board. So we're entitled to the total density 3.92 or whatever that fraction
Are you
is.
saying that without the workforce bonus, the developer could put 3.9 units on the property?
Absolutely. I just can't build a 9/10 of a unit.
And how do you find 0.9 of a unit?
That's what I just said. I can't build it. I'm allowed to, but I can't build it. But that's my density. And respectfully, that when we apply the bonus to that number, we get to a fraction that's, I believe, 6.8 units that are allowed on the lot. Again, with the bonus. I can't build that 8/10 of a unit, but that is the lot density. That fractional number is, under the ordinance terms, that's my lot density. I just am restricted to what I can put on the lot.
And going back to subsection 3A, you are saying that this project meets the open space requirements?
Because there are none for this workforce housing
Right,
project.
that's what, it's in compliance with you.
Yeah, yes, Your Honor, and I'd point out that the planning board did require us to include open space under, I can't remember the number, a separate ordinance section.
5.10.2.
Thank you. Yeah, we're required and have a condition of approval that requires us to maintain that at a minimum of 1,600 square feet.
Can I take you back to the declaration and to Mr. Burns' point about the unit?
Yes.
And the difference between the definition of unit and unit boundary in
Yes.
section 3.2? 3.2 says the unit shall be bounded and depicted as on the plat and shall include everything located on the site,
Yeah.
including any buildings or structures.
Yeah.
I mean,
So,
how do you read that?
yeah, so first of all, the court should be aware that the planning board was not presented with a condominium plat. We gave them a subdivision plan, and you'll see on that plan, it doesn't include boundaries. It includes the approximate maximum, or what we said on the drawing was the maximum size, so the maximum footprints for homes that would be placed on the lot. The subdivision plat is coming later. The reason for that, as a practical matter, is that we haven't bought the houses yet, and because of the delay, these are going to be modular units, as the narrative to the planning board indicated, that are going to be purchased by the, with the assistance of Mount Desert 365 by the unit owners. Those units will become, once we decide which vendor we're using, what they're going to be, there'll be a condominium plat that'll get recorded that'll show what the units are.
Can I ask about section 3.8 then? Under your definition, what would it mean to relocate a unit boundary?
Yeah, so those are for the duplexes. So the intent there was that if the two unit owners, as you know, this project is going to have 2 duplexes on it. If the unit owners decided that they were going to change the square footage to change the
tear
common
down
law.
a wall, literally.
Yeah, exactly. And change the square footage of one versus the other, that's what that section is designed to accommodate. So unit is defined, getting back to your question, as the physical portion of the condominium. There is no conveyance language that's included in the condo deck here that ties into the Short Form Deeds Act. There's no quitclaim, no warranty, no conveyance, none of the language that we would see with a real estate transaction. So,
What is 3.2 talking about when it says everything located on the site?
Yeah, it's talking about
including buildings.
Yeah, so unlike many condominiums, the units are going to include the outside of the units rather than just the interior of the units. In other words,
Because they're freestanding, and some of them are freestanding.
Other than the one existing building that's there, all the rest of these are going to be freestanding modular homes. And the unit owners are going to purchase them. That includes everything on the outside. We have some control in the bylaws of what they're going to look like, the appearance, the color, things like that. But they're going to be owned outside by the unit owners.
Can I confirm, I want to be clear because where you're coming from on this. With regard to, I understand your position with regard to the lots, and you would agree that if in fact it was more than 2 lots and it had to have a road as opposed to a driveway, that is not met, correct? You would
Yes,
agree with that?
I do.
All right. With regard to density, your position is that the open space, I know the red light's on, but You know, I'm exercising a prerogative. With regard to density, your position is that the open space requirements under 5.1623 were actually met anyway.
Yes.
And then with regard to the performance guarantee, is it your position that essentially what the appellants are arguing is in fact what's in place, i.e. that all improvements necessary would have to be made?
Yes, by conditional agreement.
Including the road?
By conditional agreement, which the ordinance refers to, yes.
Okay, thank you.
Thank you very much. Thank you for your time this morning.
Attorney Burns, I believe you reserved some time for rebuttal.
I did, Your Honor. First, I would turn to the open space provisions. As was asked to the appellees, and as counsel for the town indicated, the terms cluster and workforce are used interchangeably throughout these two ordinances.
Well, if you do the calculation, what they're saying is if you do the calculation for workforce housing, they would meet it.
Respectfully, Your Honor, the planning board would be the body that would have to make that factual finding in the first instance.
And did the planning board also independently, in any event, under 5.10, require some open space?
It did. That section is discretionary. It allows the planning board at its discretion to, so 1,600 square feet were set aside. However, the planning board determined as a matter of ordinance interpretation that 5.16.2. The open space provision contained in 5.16 did not apply to this project and therefore undertook no fact finding to determine what, if any, open space would be required under that provision. That is a factual finding that the planning board would be required to make if that section was applicable. The appellees can now argue that they meet it anyway, but that's an argument that the planning board in the first instance would have to decide. Additionally, I would like to point specifically relating to that question of the interchangeable use, the appellees noted section 3.5 of the land use zoning ordinance. I would point the court to note K that is part of section 3.5. That note again groups workforce and cluster subdivisions into cluster subdivision standards. The intent throughout the ordinances, based on the structure provided here, is to regulate these two types of developments similarly, except for as otherwise indicated in section 5.16. The goals of both types of developments are the same. And if there are no additional questions, I will rest on that.
There don't appear to be.
Thank you.
Thank you. Thank you, counsel, for the argument this morning. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. With that, we'll be in recess on this matter.
All rise.
Good morning, you can be seated. The next matter is Somerset 24-402, and this is, I'm told we can use Tina Hogan versus Kennebec Valley Community College. I see counsel are present, I assume ready to proceed. We are being streamed live on the web by both video and audio. If counsel would identify themselves for the record by saying your names together with the parties you represent, starting with the appellant.
Good morning, Your Honor. Tim Zarillo, along with Seth Russell, for the appellant Tina Hogan.
Good morning. Gina McCormick for the appellee, Kennebec Valley Community College.
Thank you. Attorney Zarillo, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. Madam Chief Justice Stanfield, Justices of the Court, along with Seth Russell, I represent the appellant Tina Hogan in her oral argument here today. May it please the Court. KVCC disciplined the appellant under its code of conduct. However, there is also another rule book, the Student Issues Arising at Clinical Affiliates rule book, which we've been calling the IACA, which must be applied before the code of conduct is applied. Now, to get to that proposition, we first look at the code of conduct found in the administrative record at page 82, section 3 sub A, specifically discusses student issues arising at clinical affiliates and says, once the procedures and sanctions of those policies have been applied, the provisions of this code shall apply. When you read that in harmony with subsection E of the IACA, that makes a lot of sense. That's found at Appendix 84. The IACA says the code of conduct may, in addition to the above procedures, also apply. Application of the IACA is a condition precedent to the application of the code of conduct. KVCC plainly applied the code of conduct, not the IACA, to the April 12th, 2022 disciplinary incident. The IACA requires that the student must be provided an opportunity to be interviewed. The post-interview, there is a report to the department chair. Then the student must be given a right to appeal to the college's chief academic officer. It's only after that process that the code of conduct might apply. And none of the procedures related to the IACA that I just laid out were followed when it comes to the appellant. She was never given an opportunity to be interviewed before the discipline. She was not given her clinical supervisor's written findings until May 13th, 2022. By that time, she had already been removed from the therapy program, respiratory therapy program. In fact, Dean McKenna, who issued the removal from the program, prohibited her communication with her clinical supervisor. So there was no way for her to even know what the allegations were. Then McKenna added a new allegation as grounds for dismissal, the March 17th, 2022 incident. And you can see that easily by comparing his first letter to her at Appendix 108 and then his second letter to her at Appendix 109. And I could not help but think of the Queen of Hearts in Alice in Wonderland. Sentence first, verdict afterwards. I'll be happy to take your questions.
So the IACA isn't in the record, is it?
What you were referring to seems to be attached to the brief below. Is that to be clear?
The IACA is in the record, I believe.
It's not in the administrative record, is it?
I don't recall it being in the administrative record. It is referenced, I know, in the complaint, the first amended complaint that is made in this case, but I don't recall whether it's in the administrative record or not.
Well, you argued, I think we should take judicial notice of it, but we can't, and you didn't move to expand the record in front of the Superior Court.
Well, I don't recall that, and I wasn't counsel at that time, but I don't recall looking at the records that happened, Justice
Well, let's move to your other opening argument, where you discuss how there was a citation of one set incident, and then the findings were related to 2 days of incidents. Right. And you talk about other problems with that initial process. There was a remand. There was a new hearing ordered. There was a new hearing, and none of that happened in the new hearing, did it?
Well, by none of that Well, first I will say that I'm not sure that would cure the problem, because she had already been suspended and then removed from the program without any notice or opportunity to be heard related to that March 17th incident. But also, by the time in 2023 she comes back to the disciplinary committee after Mills has remanded the action, then that finding adds new allegations that she was never noticed of, a November allegation, for example. So what happens here is every time she actually goes to a disciplinary hearing, new allegations retrospectively are added.
You're saying that in the second hearing, she didn't have notice of all the charges against her that were ultimately identified in the findings against her?
Again, I was not there personally, but I cannot from the record see that she was given notice of those other allegations.
By the time of the second hearing, she didn't know about the other allegations? I understand that there's a question of whether she knew them at the time of the first hearing, but wasn't she given them at that point?
What I mean to say, so I should clarify that response to Justice Connors, what I mean to say is they added additional allegations, not the March 17th, 2022 allegations at that time, but in 2023, in August of 2023, when the disciplinary committee issues, after its remand, its letter to her saying she's removed from the program again, it adds in 2 other allegations as grounds. Those 2 other allegations, I do not believe, I cannot see in the record where she was given notice of them.
Can we go to the issue of count 3, the unlawful discrimination case? First of all, you do agree that in the dismissal hearing in 2023, that the college did deal with the issue of bias. I mean, there's a specific finding. You may disagree with it, but there's a specific finding.
I do disagree with it, but I agree with you that there is a finding in August of 23 that they find there's
and
no
I'm looking at your requested relief, and it seems that the relief you want is the same relief that you got, or that is available to you under Rule 80B. It says, you know, to reverse the dismissal and join them from maintaining any record of the endangerment in her. And then it says, award her damages. But she did graduate, is my understanding. Is that right?
She graduated, but not with a respiratory therapy degree. She graduated with some sort of general associate's degree that was not in the respiratory therapy program. But I would just add to that, though, that as it relates specifically to count 3, and I would acknowledge, unlike count 2, the First Amendment complaint the trial counsel put forth alleged discrimination for the entire 2 years she was involved in the respiratory therapy program, as opposed to merely the time period related to her dismissal from the program.
But what relief are you seeking in conjunction with the alleged discrimination for that entire time?
Well, she alleges money damages.
But did you bring a personal capacity claim for money damages?
Without having the, again, I apologize, I didn't draft it, but my understanding was that was her request in her First Amendment complaint.
But I thought only KVCC was named as a defendant. In other words, McKenna wasn't named in his personal capacity for a request for money damages.
I think that's correct, yeah.
So you can't get damages?
Well, whether or not they would have been able to, I would agree, again, I didn't draft that, but
in fact, KVCC isn't a person under Section 1983. So there goes count 2.
Well, yes, but I agree, but I was just talking about count 3.
Right.
And perhaps that would be how this court ruled. I don't know the answer to that. I don't think it's been settled, and somebody will correct me if I'm wrong.
But your argument about count 3 is that count 3 was more expansive as to the scope of discrimination about which she was complaining than was count 1, the 80B claim.
Yes, I think that does distinguish count 3 from count 2, in that as I read the First Amendment complaint, she alleges 2 years of educational discrimination in count 3, as opposed to in count 2, really more complaints related to her dismissal from the program.
Do you think that was explicitly argued at some point at the Superior Court level, so it was made clear that count 3 was including a different claim of discrimination than count 1?
Well, Justice Connors, you raise an excellent point, and I would just say, again, I was not there because I was not involved at that time, but I am taking that from reading the First Amendment complaint myself, and I take it that Justice Stokes could have as well.
Well, we have a record in which we know that discrimination was discussed. We know that she filed lots of materials, including materials explaining why she thought she was discriminated against, and it's pretty general as to why she thinks she was discriminated against throughout the program, not just this incident. So when they said we didn't see any discrimination, they've got a record in front of them which includes a claim that seems broader than just the specific incidents, don't we?
Well, I would say that, if I could answer that in 2 parts. First of all, I do think the First Amendment complaint is specific as it relates to her discrimination claims, and I've laid them out in the blue brief. Second, as I read the August dismissal from KVCC, part of the reasoning is that she did not raise the discrimination claim at KVCC before her action. And I'm not sure that's a prerequisite for her action. So I don't know.
I didn't follow that. Can you?
I'll try, yeah. So in other words, KVCC, in the August dismissal, the final, I'll just call it the final dismissal from the program post-remand, KVCC indicates that she did not raise discrimination claims earlier, and as a result, that is a reason why they don't credit them.
But, yeah, but they didn't take it as a waiver. They just said that goes to the sort of, the factual credibility of the claim if it wasn't raised contemporaneously. So but they didn't treat it as a waiver.
No, they didn't. Well, I take issue with how substantive those findings actually are, Chief Justice. I know KVCC disagrees with me on that. To me, to ask a woman who's a Chinese national who's struggling to get through this program because naturally English is a second language and so on, and she's working hard and has good grades, all up until five clinical rotations before graduation, to expect her then to start waving a flag saying I'm being discriminated against during her course of academic study is too much to ask. She instead brings an action. She brings a complaint, then a First Amendment complaint, and in that First Amendment complaint, as I was trying to say to Justice Connors, she certainly specifically lays out claims of discrimination, claims that she's discriminated against compared to white students.
And claims which, on the merits of the claim, the disciplinary hearing found was not the basis of what was going on.
Yes, I would agree.
And
I would
those
agree
weren't
that's
attacked.
the case, but disagree.
Those findings were not attacked in the ADB proceedings. He said, I'm doing the ADB first, and there was nothing in the ADB briefing challenging that or saying why you couldn't deal with that in the ADB.
It's part of the problem, a procedural one that Justice Stokes in his first order said, basically, I'm denying the dismissal on count 3 at this point. I'm not going to rule on it until after we finish disposing of the ADB. And so the thought was we would then, after we get a ruling on the ADB, turn to whether there's anything remaining on count 3.
I do agree there seemed to me to be considerable confusion by that with trial counsel, and I think that the distinction between the 2 Stokes orders is confusing to me as I read it, and I would say to Justice Connors, if I may go backwards, even though the red light is on, I would agree that that's probably the record that I'm stuck with based on your last point.
Thank you.
Thank you.
Attorney McCormick, we'd be happy to hear your argument.
Thank you. May it please the court. I would like to begin with the fact that we are here today discussing an academic decision of a community college. That decision to dismiss Ms. Hogan from the college's medical education program in respiratory therapy was made after multiple third-party hospitals informed the college that she was endangering patient safety. And that decision was made after Ms. Hogan was given a robust process. Counsel for Ms. Hogan today has stated that Ms. Hogan was not notified of any information from the hospitals prior to the dean's suspension. But that is false, and the record shows otherwise. The dean informed Ms. Hogan that he learned of this information in a letter dated April 15th.
I see that the green light is on. Can I turn to count 3? In fairly reading the count 3 of the amended complaint, the allegations are far more broad than what may have happened in these clinical situation. In other words, she says in paragraph 37, generally that she experienced discrimination and harassment because of her race and national origin. 38, that teachers and staff told her they couldn't understand her, ignored her questions, didn't respond to her requests for help, treating her differently than requests from other peers who were not Asian. That they applied its policies differently to her than it did to students who were not Asian. It failed to include her in assignment grades, exam prep meetings. I mean, aren't all those things that are outside the scope of the ADB issue of the discipline?
Your Honor, if we go on to paragraphs 41 and 42 that follow those factual allegations you just described, it becomes clear from count 3 of the complaint that the way it is pled, those allegations all lead up to the disciplinary committee's decision. And when the trial court made its decision to dismiss count 3 as duplicative, it was after reviewing the ADB record and the allegations of the complaint and concluding that it all related back to that disciplinary committee's decision.
So is it as simple as how we read the complaint? Because, I mean, below it was dismissed as a matter of law as being duplicative. And if I view this complaint as including allegations beyond what was or could have been adjudicated at the discipline hearing, does that mean that the complaint survives at this moment? Now, ultimately, it may not as a factual matter, but.
Well, the standard of review that we apply to dismissal of independent claims in an ADB action is abuse of discretion. And so I think that what we need to be doing is looking at whether the trial court abused its discretion when it dismissed count 3 as duplicative.
How do we apply abuse of discretion when it's a legal conclusion?
I believe that the way it would be applied is whether the legal conclusion that the trial court reached was so outside the bounds of a judicial officer's judgment or discretion that it cannot be upheld. But another thing to consider here is in the administrative record for the disciplinary hearing, the second one, Ms. Hogan submitted 515 pages of documents. That's all of these documents to support her position. And in that, she discussed the allegations.
I don't think there's any question that she discussed a claim. There was a claim of discrimination raised in the disciplinary hearing. I think the question to me is whether there's something that remains that's outside of what was or could have been decided in the disciplinary hearing.
And I believe the answer to that is no, because of the fact that that count 3 relates to the disciplinary committee's decision. The facts leading up to it are a factual predicate that she uses to suggest the decision was somehow discriminatory.
Sorry to interrupt. Suppose we were to interpret it differently, that these were separate claims of discrimination apart from the way the disciplinary proceeding was handled. What relief do you understand Ms. Hogan to be asking for in this case, and would that relief be available as a matter of law given the way the complaint has been styled?
Right, thank you. And I think that's an important second part to the dismissal of count 3, which is that the relief that she seeks, again, is relief that's available under 80B because she is seeking to have the disciplinary committee's decision overturned so that she can be reinstated into the respiratory therapy
Are you saying that to the
program.
extent she's seeking damages, including for lost education opportunities, job opportunities, reputation, emotional distress, et cetera, that is all precluded by the administrative finding that the termination or that the discipline was not being imposed in a discriminatory fashion?
Well, Your Honor, the case law that we rely on in our briefing does cite to precedent where even if monetary damages are additional relief that may be available in an independent claim, that does not mean that the claim can stand alone. In other words, just because she may be entitled to monetary relief on a discrimination in education claim doesn't mean that is a basis to allow that to be a standalone claim.
You said at the outset of your remarks today that this was an academic decision. Why wasn't it handled under the policies and procedures for the respiratory therapy program with the opportunity for probation, three attempts to pass the competency exam, et cetera?
Yes, so the academic misconduct that is at issue in this case is patient safety and endangerment. And when the dean was informed that third-party hospitals were concerned about the safety of their patients, he used his discretion to apply the code of conduct. The code of conduct is very clear in that it can apply in instances when the health and safety of members of the college community, which is defined broadly, is endangered.
So the appellee's position apparently is that a student in the program forfeits the opportunities under the respiratory program policies if the college chooses to go with the code of conduct?
Not exactly, Your Honor. I think the misconduct at issue in this case was not what we think of as quintessential academic misconduct. It is not plagiarism. It is not cheating on a test where probation may be appropriate. The facts on the ground here are that an educational institution has learned of a safety issue and applies this. And to be very clear, there can be no dispute that significant process was given to Ms. Hogan. Just like under the incidents arising at clinical affiliates policy, where she would have the opportunity to speak with faculty members, to learn of the allegations against her, she had that same opportunity under the code of conduct at that April 21st meeting.
I thought quite a lot of the concerns expressed had to do with what is referred to as clinical procedural competency. In other words, issues that had to do with Ms. Hogan's capabilities as a potential respiratory therapist. I mean, was there any allegation of plagiarism or?
No, there was not, and I think that's the point that I was attempting to make, but perhaps did not do successfully, which is if you look at the code of conduct, there's two subsections. There's A and there's B. The type of conduct that is described in subsection A, where appellant's counsel gets the language that says the issues arising at clinical affiliates policy must be provided first, deals with what is typically viewed as quintessential academic conduct. It says plagiarism, cheating. But then what we applied was subsection B, which was conduct that disregards the health or safety of the college community, and it does not have that express language saying that the incidents arising at clinical affiliates policy must be applied first.
We have a finding here that because of the timing at the close of she was getting close to the end of the program, and the severity of the incident reports, that it amounted to negligence. So, and that finding in the ADB has not been attacked. So understanding that this is negligence, it's your position that that's more applicable to the code than the handbook?
Yes, it is.
And what is your position on citing to the IACA guidance?
Well, I do think first, the IACA is not included in the administrative record. And what is included in the administrative record is the code of conduct. And that is what the trial court was focused on when it made the dismissal decision. And the trial court even noted in its decision, which is at Appendix 19, the decision to proceed under the student code of conduct is for the college administration, and this court has no authority to intrude on that decision.
But if the code of conduct clearly did not apply, I mean, we could certainly say so, couldn't we?
If it clearly did not apply, then you could.
So the position that you're taking is really as simple as it does apply, there's nothing in it that says that it doesn't apply, and even if there are other codes such as the IACA that could apply or may be appropriate, A, may not be in the record, and B, that's a reasonable choice for the college to make.
Exactly.
Is KVCC a person under Section 1983?
KVCC would be a municipal entity.
Municipal?
A quasi-governmental.
Well, there's a big difference.
Yes,
under
there is,
Section
and I misspoke, Justice Connors. I did.
So if they are an arm of the state, then aren't you just immune to all Section 1983 claims?
Yes, we would make an immunity argument. That was not something that was briefed below. The 1983 independent claim was decided on the grounds that it was duplicative. And I also think even if it hadn't been decided as duplicative, the plaintiff in this case simply cannot prevail on a due process argument where an academic decision, such as this one, only requires careful and deliberate decision with notice.
Well, you can't really call it a disciplinary issue under the code and then say, oh, but it's academic. I want the academic test under the, because that's the handbook.
Right, but I think that's an important thing to address, which is that the code of conduct applies to academic issues. Students can be disciplined for academic misconduct, and the misconduct at issue here does not fit neatly into what we traditionally think of academic misconduct, but the facts on the ground and under the case law make it very clear that when we have a student in a medical education program putting their skills that they have learned from the classroom books in practice in such a way that they are deficient and unable to continue in the program because it is raising a safety issue, that it absolutely relates back to an academic shortfalling.
Isn't your better argument as to why the due process claim, Section 1983, doesn't state a claim, is because the ADB process gives them all the procedural due process that's due?
Well, yes, Your Honor, that is the better argument.
There was just some discussion about immunity. Would KVCC as a governmental or arm of the government be immune from a claim under the Maine Human Rights Act?
I do believe that a student can bring a claim under the Maine Human Rights Act against an educational institution.
Can you get damages for an educational discrimination under the statute?
Yes, that is permissible.
There don't appear to be additional questions. Thank you.
Okay, thank you very much.
Attorney Zerillo, I believe you reserve some time for rebuttal.
A short time for rebuttal. Thank you, Your Honor. And in fact, on that last point, Ms. Hogan did go to the Maine Human Rights Commission and get a right to sue letter before proceeding here. The other thing I don't think has been addressed, but I want to make sure to raise, is simply that To our view, there is an added distinction that when Dean McKenna suspends her without any notice or hearing, that is something that needs to be accounted for by this court. She has no idea not only what she's being suspended for, but she's not even allowed to.
But unlike
ask questions.
Gorham, it's not like there's lost wages, and ultimately, that suspension was maintained. Isn't it at this point, even if you're right, that she should have had more process at that early stage, doesn't that really become harmless error? What's the harm?
Well, I would.
After the fact, if we uphold the hearing of the full hearing.
Taking your hypothetical, then I would suggest that the First Circuit's decision at Haydick that we talked about in our reply brief should be something this court should consider. And there, in that case, a student was disciplined. Ultimately, that discipline was found to be justified, and the First Circuit said you at least need to award
That was an actual, that was a high school, and that was not dismissal from a program. It was dismissal from education that there was clearly a public right to, correct?
I could be wrong. I did not think it was to a high school, but I stand corrected.
It may not be, but it was not to a program, right? It was dismissal.
From the college.
Yes.
And that was not, I mean, and again, that one, the Haydick case was not purely academic. Clearly, it related to a stalking allegation related to a boyfriend.
And what they said was nominal damages.
Well, they said nominal damages, but here, the case was just dismissed. She was removed from the program, and the case was dismissed. There may be, the law is not good here on this yet, but it may be this court wants to draw a distinction between an academic program and dismissal from the college. But our view is this is tantamount to dismissal.
Thank you.
Thank you.
Thank you, counsel, for your arguments this morning. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, I believe we are in recess.
All rise. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, sitting as the law court, may hence depart and give their attendance here at the call of the Chief Justice, as this court now stands adjourned. God save the state of Maine and this honorable court.